This is Free to Exchange, the show where free-thinking scholars, free markets, and, ironically, free public television all meet. I'm your host, Ben Powell. Most people believe that the creation and enforcement of law must be provided by a government. My guest today might challenge that idea. We're going to explore some legal systems that are very different than our own and the economic incentives that make them function. My first guest is Dr. David Friedman. Dr. Friedman is a professor of law at Santa Clara University. He's also the author of the classic book, The Machinery of Freedom, A Guide to Radical Capitalism. David, welcome to Lubbock and to the show.
Thank you. I've been enjoying myself. My current book project is a book on legal systems very different from ours. And if we had a couple of hours, I could tell you about a whole lot of fascinating systems, ranging from Periclean Athens to the modern Amish. But since the particular question you're asking about is systems which enforce law in different ways than we're used to, I thought I would mention a few examples of those.
Sounds great. This is going to be an easy interview, David.
And I will start with the one closest to our system, and that's 18th century England, which is what our legal system grew out of, basically. And I'm not sure that many people realize that in 18th century England there were no police and no public prosecutors, that crimes were prosecuted mostly by the victim. It was private prosecution. Legally speaking, any Englishman could prosecute any crime. The police don't develop well into the 19th century. That's one example, but there are much more extreme ones.
Well, let's stick with it for a minute then and describe it. So there are no police and victims enforce their own crime. How does a victim enforce?
Well, the victim doesn't enforce the judgment. You've still got a government court, and the government ends up hanging you or whatever the punishment is. But the person who does the job that the police and prosecutors normally do of figuring out who did it and proving it to a court is a private actor, usually the victim, so that somebody steals something from you, you somehow find out who did it, you go to the local constable, which is an unpaid position, basically to which one of the local householders has been drafted into. He's got to do the legal process of the arrest. The local magistrate, you then go to the local magistrate, who's also an unpaid volunteer, a sort of member of the local elite. Eventually you end up in a court, and in that court it's up to you, the victim prosecutor, to provide the evidence. Now, there were also some professional thief takers.
I was going to say, that doesn't sound like most people would, be very good at prosecuting their own crimes.
The real puzzle is not that so much, but why anybody bothers. And again, we've got limited amounts of time, but if people are sufficiently curious, I've been webbing the draft of the book I'm writing on my webpage for comments, and if people go look there, I have a fairly long discussion of what the incentives were, of how you make it in the interest of the victim to do it. And one way is you have rewards for successful prosecution. One way is that I prosecute you in order that you will pay me off to drop the prosecution, the equivalent of an out-of-court settlement in a tort case now. And one way is that I prosecute you in order to deter other people from robbing me. And they had some ingenious institutions to make that workable to do.
So part of it was almost restitution-based then?
Well, if you actually win the case, you don't get restitution. If you win the case, they hang him or they transport him for 14 years indentured servitude in the New World, or any of various other things can happen. If for a minor offense, like an assault, it's legitimate to have an out-of-court settlement and basically say he's compensated me. But for a felony, which almost all were in theory capital, although a lot of people didn't actually get hanged for various reasons, you're not supposed to settle out of court, but in fact people pretty clearly do. And I can't officially drop the charges, but I can not show up when I'm supposed to prosecute.
Sure. If there's gains from trade to be had, people would realize
But this is actually a system a good deal closer to ours than a couple of the other ones I've looked at.
So let's talk about one that you're famous for, studying medieval Iceland. That's a bit different than ours.
Saga period Iceland is my favorite one of these systems. That's a system where you have a legislature, you have a legal code, you have a court system, and there is no executive arm of government. So after you get your verdict, it's up to you to enforce it. And the basic logic of the way that system goes is that if the court says you owe me damages for something, which could be anything from cutting wood in my forest to killing my brother, you do or don't pay the damages. If you don't pay the damages, you get outlawed.
What does that mean, outlawed?
It means it is now legal to kill you.
So you're literally outside the protection of the law.
It is legal to kill you, and it is illegal to protect you, feed you, shelter you. Now, it's a little more complicated than that.
So this would be your incentive to actually pay them because there's not a police force to enforce the verdict.
Again, I'm simplifying a good deal given our time constraints. And lesser outlawry is you're outlawed for 3 years and you're entitled to leave Iceland for that time. And if it's not in the season where ships are going, it's not legal to kill you as long as you stay in a small area, sort of your own home and near your home, until you can leave Iceland. Greater outlawry, you're fair game from the beginning, basically.
What would happen if it's a weaker person against a stronger person?
Yeah, that's one of if you think about what I think of as feud systems, as systems where you have decentralized private enforcement, which is not true really of the English system, but is true of the Icelandic and a number of others I've studied. And one of the problems in the basic logic of a feud system is if you wrong me, I threaten to harm you unless you compensate me. And in the Icelandic case, most of the cases are not actually settled in court. Most of them are out-of-court private settlements between the parties. And if your crime was actually killing somebody and it went all the way through the court, you're going to get outlawed even if you're willing to pay. But in practice, you don't, because before it gets that far, you end up to an agreement with the heirs of the person you killed, in which you pay damages and they drop the charges. But let me go back to your question. And the answer is that in that system, the claim I have when you have wronged me is a transferable, marketable claim. So I'm an elderly man, I've got one son, and you've killed him. So if I try to sue you, I'm going to get beaten up on my way to the court, even before you get outlawed.
Right.
However, my neighbor is a wealthy farmer with 4 tough sons who went a Viking in their youth and lots of friends and relatives. So I transfer my claim against you to him. It's a claim for 200 ounces of silver, which is a whole lot of money. He now enforces that claim. If it's easy to enforce, we probably agree that he gives me some of the money. If it's hard to enforce, maybe he doesn't give me any of the money, but the guy who killed my son has ended up either paying a large fine or gotten killed, and that's a reason not to kill even the son of a poor or weak person. And in fact, I've argued that in this respect, the modern American legal system is a mere 1,000 years behind the cutting edge of legal technology, because in our tort system, it would be quite useful if you could transfer your claim, that if you are somebody who can't afford a lawyer, or even somebody who doesn't know what lawyer to choose, and someone smashes up your car, life would be much easier if you could just auction off to the highest bidder, which would presumably be a law firm, the right to collect damages.
And because our rights aren't transferable here, we're
you
1,000
can't
years
do it.
behind.
We've got various partial ways of doing it.
Let me ask you one more question about Iceland, because people who are familiar with the sagas might think of it as a violent time there. How well did this legal system work at preventing violence from occurring?
We don't have good murder rates for 1,000 years ago. One scholar, the system lasted for about a third of a millennium, about 330 years. And it's breaking down in the last 50 years, roughly. And one scholar went through the sagas covering that period. And the sagas, the killing tends to be very small scale and individual, and counted bodies. And it looked from that as though the death rate from that was roughly comparable to the U.S. highway death rate, or what the U.S. murder rate was 15 or 20 years ago when it was higher than it now is. Something like, I think, 10 per 100,000 was his estimate. But we're not really sure how reliable that is. On the other hand, if you compare it to other contemporary societies, my guess is that England, Norway, and Normandy lost a larger fraction of their population to violence in 3 weeks of the year 1066, which covers 2 battles, than Iceland did in 50 years of the final breakdown of that system.
Okay, so we've got just a few minutes left here, and I'd like to explore with you just a little bit of, you've studied all these different legal systems. What ideas would you have about their relevance for a modern, wealthy society, and how might our legal systems function better other than transferring our torts?
There are two answers. There are other examples of ideas from other legal systems, not necessarily feud ones, but there are 2 answers. One of them is that you can make sense of some things that happen in our society if you think of them as sort of a disguised feud system, so that Apple could sue Samsung claiming they're violating their patents. Even if it's a weak case, that'll make it harder for Samsung to sell phones, which Apple would like, but Apple is going to be limited in their willingness to do that because Samsung can sue them. So you can think of a lot of the ways in which private norms are enforced or in which people use legal threats against each other to constrain their behavior, you really get the logic of a feud system, even though you don't call it that. For a full-scale version, my first book, The Machinery of Freedom, which was published over 40 years ago, has a chunk, part 3, in which I sketch out a hypothetical future society like our society, but in which law enforcement is private and decentralized. And I don't think I can do justice to that in 30 seconds. However, you can download a free PDF of the second edition from my webpage, and if you're feeling rich, you can buy a copy of the third edition for about $10 from Amazon.
It's a great sales pitch. And give me a little bit more of a teaser. How would justice be enforced?
You would have private firms that sold the service of protecting people's rights to them. Those firms would realize that there was a risk that the customer of one firm would think the customer of another firm had wronged him, and you don't want to get into a shooting war because that's very expensive. So each pair of firms would find it in their interest to contract to agree to a private arbitrator, to a private court that would settle disputes. And what enforces that contract, because I'm now imagining you go all the way to a world where there is no government or government law enforcement, is the fact that they're repeat players. That if my firm doesn't abide by the agreement when we lose the case, then your firm won't abide by the agreement when you lose the case. And then the next time we have a conflict, we end up fighting each other, and then all our customers shift to some other firm that's more reasonable in how they protect their rights.
Similar to how firms' reputation in international arbitration enforces agreements today.
Yes, there's a lot of, as you know, there's a lot of private enforcement of various forms in the modern world.
All right, well, it's been fascinating. Thank you very much for joining us.
Thank you.
If you thought this segment pushed the limits, just wait until what's up next. Our next guest is going to explain why seemingly bizarre legal practices, such as ordeals like boiling a person's hand in water and examining the wounds to determine guilt or innocence, were actually efficient legal practices in the environments where they were used. Stick around.
Free to Exchange is a joint project of Texas Tech's Free Market Institute and Texas Tech Public Media. More information is available at fmi.ttu.edu.
Welcome back. Joining me now is Dr. Peter Leeson. Dr. Leeson is the Duncan Black Professor of Economics and Law at George Mason University. He's also author of a series of research papers explaining how some seemingly bizarre legal systems actually worked well at their time. Pete, welcome back to the show.
Pleasure to be here. Thanks again for having me.
So in the transition, I said we're going to talk about ordeals. This seems patently crazy. Well, first tell us, when were they used? What is an ordeal to determine guilt or innocence?
So ordeals are a sort of physical test that is used by a legal system to determine the guilt or innocence of an accused criminal. And they took a variety of forms. I'll talk a little bit more about that, I think, in a minute. But they were used pretty much the world over, certainly all of the Western world, from as far back basically as we know, certainly going back at least as far as the 9th century, all the way up until the beginning of the 13th century. So we're looking at the better part of 500 years, perhaps even longer, in which they were used.
So instead of hearing testimony and trying to determine guilt or innocence, they were going to take someone's hand and stick it in boiling water? And this makes sense to you?
Well, so that was just one form, but I should point out that part of the craziness comes off of the surface when you realize that these were only used to try difficult criminal cases. If somebody had, stabbed someone and some bystander saw it, the courts would use during this period would use that testimony to try and figure out whether or not the guy had in fact committed the crime. But you have to remember that, we're talking about the Middle Ages here. We're talking about a period in which, light posts didn't even exist. So a lot of stuff is happening in the dark. Criminal fact-finding methods in general haven't been well developed. And it's for these types of cases where courts would, quote, fly to the ordeal. And the one that you mentioned was perhaps the most famous. And what they would do, a court would have a pot of water brought to a boil. All of these, I should say, were overseen and administrated by clerics, by priests. Religious institutions and secular institutions were intimately tied together and connected during this period of time. So into this pot of boiling water, they'd throw a stone or a ring, and then they would ask the accused criminal in this difficult case, who's guilt or innocence was not obviously known, where reliable testimony wasn't available. They'd asked him to plunge his arm into the water and to pluck out the stone or the ring. This defendant was called a proband. And they would then wrap the arm of the defendant and inspect it 3 days later. If the arm showed serious harm from having been boiled by the water, as you might expect would happen, he would be convicted of the crime. And if the water left his arm unharmed, he would be exonerated from the crime.
And why would he be exonerated?
So the idea behind these was this idea called judicium Dei, that ordeals were judgments of God. Remember again that it's priests, it's clerics who are in fact conducting these things. The idea was, well, we don't know whether or not the accused criminal has committed the crime, but God knows. His eye is everywhere, he sees all. So if in fact the criminal defendant is guilty, when he plunges his arm, God will allow the water to boil his arm, and thus when he removes it, we'll see that and we'll know that he's guilty. On the other hand, if the proband is innocent, God will perform a miracle for the proband, evidencing his innocence to the court, and in doing so, exonerating him.
Did God step up to the plate here?
So, no, God didn't step up to the plate, but economic logic and priests did. So
Okay.
the key to understanding how this could be an effective fact-finding method is to step inside the shoes of, or rather the mind of, a medieval proband. This proband believes in this superstition of, or what we would consider now to be a superstition, of judicium Dei, that God in fact intervenes in judicial and other worldly affairs to tell us what's going on. So suppose that you're a criminal defendant. You know whether or not you've committed the crime, but the court doesn't know. That's what it's trying to find out. If you're innocent, you expect that if you plunge your arm into the water, God will in fact perform the miracle for you, right? You'll come out unscathed, so you'll be exonerated. Therefore, the innocent proband is going to be perfectly willing to plunge his arm into the boiling water, conditional on him believing in this superstition. The guilty proband, however, faces a very different calculus. He expects that if he plunges his arm into the water, not only is God going to allow the water to boil him, in consequence, harming his arm rather severely, but furthermore, that now that he's been convicted of the crime, that God has evidenced that in fact he's guilty, he's going to face the state official sanctioned punishment for whatever crime he's just been found guilty of. So his calculus is, well, if I undergo this thing, my arm gets boiled to rags, plus I end up suffering the penalty, so it perhaps is better if I just either decline the ordeal and flee, which sometimes people did, or confess, in which case I would get a lower punishment from the state, and I don't have my arm boiled to rags. So the guilty guy is willing to undergo the ordeal. The guilty guy is unwilling to undergo the ordeal. The innocent guy is willing to undergo it, and on the basis of that fact,
I was gonna say, this seems like a great way to get confessions, but it sounds really bad for the innocent guy.
Okay, so I'm coming to that. But
Okay.
before we get to how it interacts with the innocent guy, we need to recognize that based on the proband's willingness, his choice to either undergo the ordeal or not, the justice system now has new information about whether or not he probably committed the crime. Only the innocent guys, according to the logic I just mentioned, are going to be willing to put their arms in the water. So now the question is, which you're getting to, how is it that in fact, short of God performing a miracle, the water doesn't actually boil the proband's arm to rags? And that is the clerical piece that I came to before. So the guy performing the ordeal knows that the proband is innocent, so what these priests effectively did was turn down the dial on the stove, so to speak, to ensure that the water wouldn't in fact boil the proband.
Wow, that seems all fascinating. But it also isn't entirely out of line with something that goes on today, is it?
Yeah, so if you think about the basis of the ordeal system is this citizen's belief in something that is scientifically false, but that nevertheless the judicial system is able to leverage in order to find fact. The most close, I think, contemporary analog, which is in fact quite similar, are polygraph tests. Many American citizens, for example, believe that polygraph tests are real, that they are actually capable of determining whether or not the person who it's being administered to is lying or telling the truth. In fact, that's totally BS, right? There is no way to physiologically measure whether or not someone is lying or telling the truth. But conditional on people's belief that that's true, their willingness to undergo the polygraph test can provide some additional information about the probability that they are lying or telling the truth, or guilty or innocent, to whomever the polygraph administrator is. So instead of divining things by finding out what's happening to a guy's arm after he plunges it in water, now we look at squiggly lines on a piece of paper, now on a computer screen, and pretend that tells us the answer.
So the polygraphs are today's ordeals.
Exactly.
So let's go back to the old times and other kind of bizarre institutions to enforce property rights and law here. Cursing. And by that, I don't mean the type that you're going to get me in trouble with the FCC for. But tell me about the use of cursing in the Middle Ages in order to enforce property rights.
So if you go back to, this is again 9th, 10th century, what corresponds, it's called West Francia, but it's a territory that corresponds roughly to contemporary France. During this period, there were large numbers of monastic communities. These were, communities of monks and canons. And during that period of time, the largest property holdings, basically some of the richest guys, were these monastic communities. The problem was that for a variety of reasons, the institutions of the state during this era had basically eroded and collapsed. And so these monks and canons found themselves in a situation of anarchy. The reason that that was a problem was that there were lots of basically local strongmen who were unaccountable to anybody, who had an eye on the property of these communities and wanted to plunder them. And you might think, well, the natural way to defend your property, at least during this period, would be with swords, right, or some physical means. However, upon entering a monastic or canon community during this period, you actually surrendered all means of self-protection as a way of sort of surrendering yourself to God. So these communities of monks and canons were basically like sitting ducks for would-be plunderers who had an eye on their property. It was in the face of that situation that these communities needed to somehow figure out a way to protect their property rights without physical means and without a government. And from that, they developed the practice of monastic cursing, or what's sometimes called medieval malediction.
So what's a monastic curse that you can say on this show?
Well, I couldn't repeat them. They were in fact quite long and elaborate. But for those who are familiar with the Bible, you can find verses of them, many of them. Actually, the Bible is littered with curses in the book of Psalms. So if you look at Psalms, you'll find a variety of curses of enemies, basically of God's interests or the church's interests. And these curses were very detailed and very broad. So they would curse people in the morning and at night. They would curse them in the head and their feet, in their eyes and their mouth, when they're sleeping, when they're waking. They would curse families. The target of the curse is families. They would curse their wife to be raped. All sorts of horrendous things. Basically, what these communities of monks and canons did was that they lifted, remember these are ecclesiastics, they lifted these curses out of the Bible. Remember again during this period that the belief that people have is in fact that clerics can in fact call upon God to basically issue maledictions, to do curses that would harm them both in this world and the next to those who violate their interest. And they used those curses to protect their property rights.
And because these other people believed that this would be true as well, all of a sudden, God essentially became the army for the monastics.
That's exactly right. And a critical part of this, so you might wonder, well, if you curse somebody and the curse doesn't come true, which since presumably God wasn't in fact cursing the plunderers, how is it that this would last as a means of self-protection? And it's there that the particular form that the curses took that I mentioned a moment ago, the very detailed and yet broad aspects of them came into play. If I curse you in your head and your feet, when you're sleeping, when you're waking, in this life and the next life, when you've got a red shirt on and a green shirt on, and so on, I've basically, on the one hand, made very detailed and specific sounding curses, yet I've also covered all possible states of the world. At some point, something bad is going to happen to you. Even if it doesn't, you don't know that something bad might not happen to you in the afterlife. As a result, the monks and canons' curses were what we call unfalsifiable. They were never able to actually produce evidence that would disconfirm them. And as a result, the prevailing belief in their ability to call on God to issue the curses nevertheless remained effective over time.
Amazing another situation like this. Now, we don't have time to go into all the different areas that you've studied these different legal practices. Just from having seen so many different ones at different times, in our last minute here, what does that tell you about legal systems today, or what lessons does it have for us today?
There are several. So the first thing that I think it tells us is that things that on the surface are obviously stupid, many of them, of course, not all of them, but many of them, especially when they're institutionalized and have lasted for a long period of time, may in fact make a great deal of sense. They may facilitate our ability to govern in various ways. You can find those in contemporary legal systems, as I mentioned with the polygraph. Bible swearing in courtrooms, which is now based more or less out of fashion, but for a long time in modern U.S. history nevertheless prevailed, is similar to, you're basically asking God to curse or to in some way instill fear in the person such that they don't tell a lie. The other thing is that in the developing world, where state institutions of property protection are often absent or highly corrupt, you'll find private systems, judicial and otherwise, and institutions emerging to perform governance functions that leverage these superstitions in order to make them effective. From that perspective, it's not that the superstitions are, or that we're achieving cooperation to the limited extent that we are despite the superstition. We're in fact achieving it because of the superstition. So perhaps we should be a little bit less suspicious about superstition.
I think that's a great note to end on. Thank you again, Pete.
Thanks.
Economics is a powerful tool. It can explain seemingly bizarre institutions and behaviors in a way that makes things make sense once you take account of the problems that people were facing and the information that they had at hand. Our guests today did that with legal institutions for us throughout time and have shown us how people in seemingly difficult situations and sometimes with bizarre beliefs are able to harness those in order to provide self-governance and make their system work a little bit better. See you next time.